Welcome to all the students of SYBCom. In the previous lectures, we have seen the syllabus of a subject, that is Elements of Company Law. Further, we have started the first chapter in which we have completed the first topic, that is the background and the features of the Companies Act 2013. So, we will move on to the next topic of the first chapter, that is meaning, nature and characteristics of a company. So, let us see the first meaning and the definitions of a company. See, the word company is derived from the Latin word com, that means with or together, and penis, that is bread, which means group of persons or traders discussing matters and taking food together. Hence, we can say that the word company conveys the idea of togetherness. Why it conveys the idea of togetherness? Because a company is an association of person or association of people coming together for a business objective or for an objective of a business. So what is that? They are coming together. That is why it is conveying an idea of togetherness. In broad sense, a company denotes an association of persons formed for the purpose of carrying on some business or undertaking. A company is a corporate body and a legal person having distinct identity separate from the members constituting it. So what I said, that a company is an association of person and it is formed for a particular objective, and that particular objective is to carry out some business. Okay, and a company is a corporate body. Why it is a corporate body? Because it is created under the Companies Act 2013 or any other previous company law, and its identity is different from its members who are constituting it or who are forming the company. Okay, so this is what the meaning of company is. If you see the definition, according to section 2, subsection 20 of the Companies Act 2013, company means a company incorporated under this act or under any previous company law. So if you see the definition according to the Companies Act 2013, section 2, subsection 20, company means what? A company means a company incorporated under this act. Under this act means Companies Act 2013 और under any previous company law. और कोई भी पुराने company law के अंदर अगर वो create है या इस law के अंदर created है तो उसको हम क्या define करते हैं? Company define करते हैं. That is a simple definition which is given by the Companies Act 2013. Let us see one more definition. According to Justice James, a company is an association of persons united for a common object. So this is the another definition which is given by Justice James. Now let us see one more definition. According to Chief Justice Marshall of USA, a company is a person, artificial, invisible, intangible, and existing only in the eyes of the law. Being a mere creation of law, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. So this is a one more definition given by the Chief Justice Marshall of USA. He describes that a company is a person, but it is an artificial person, it is invisible, it is intangible, we cannot touch it, but it is existing in the eyes of law. According to the law, the company is existing. Okay, it is created by law, it has some rights and duties, and its existence is conferred by the law which is prevalent in a particular country. So this is the definition given by the Chief Justice Marshall. Okay, so these were the three definitions of the company. Now let us move on to the nature of company. See, a company has a dual nature, as an association of its members, but also as a person separate from its members. A company is an association of members or association of persons, but its identity is different from its members. That is why a company has a dual nature. Dual nature means it has two nature. We say that a company is an association of members. Yes, it is an association of members, but its identity is different from its members. Okay, that is why a simple example in accounts we would give the capital contributed by the members of the company is considered as liability. Why? Because company itself is borrowing the money from its owners only. So the company is borrowing the money from its owners. That is why the capital is termed as liability. So it has a dual nature. It is an association of member, but its identity is different from its members who are constituting it. So that is why a company has a dual nature. Since a corporate body, a company is the creation of law. It is not a human being, it is an artificial judicial person. It is clothed with many rights, obligations, powers, and duties prescribed by law. It is called a person. Being the creation of law, it carries the powers conferred upon it by its memorandum of association, which is the charter of the company. Within the limits of this charter, it can do all acts as a natural person may do. So, company acts like a natural person. It is a person in the eyes of law. It is invisible, it is intangible, but it is a person in the eyes of law. It has its own powers, duties, obligations, which are exercised by the company according to its memorandum of association. We will study about the memorandum of association in the third chapter in detail. Okay, so this is what your nature of company here means. Now let us move on to the characteristics of a company. See, there are various points in the characteristics of a company, and we will see it one by one. The first one is incorporated entity. The first characteristic of a company is incorporated entity. See, a company comes into existence on incorporation or by registration under the provisions of the Companies Act. So, for the formation of private company, the minimum number of persons required is 2. Except in case of one-person company, there is only 1 person required. And for the formation of a public limited company, the minimum number is 7. So, it is incorporated entity. Why? It is incorporated entity because it is formed under the Companies Act 2013. Okay. The next comes separate legal entity. After incorporation, the company acquires a separate legal identity which is separate and distinct from the personality of those who constitute it. Being a separate legal entity, a company enjoys the following features. For example, it can hold property in its own name, it can open account in the bank in its own name, it incurs debt, it can file a suit in the court of law, and it can be sued by others. So separate legal entity means that it has a different identity it has different identity in respect of its members. Okay, so that is the meaning of separate legal entity. Next comes artificial person. See, a company once registered becomes a juristic person. The existence of a company is created by the law. It does not have physical existence like a natural being, but it has certain rights and duties just like a natural person. So a company has nationality and a domicile, but it is not a citizen and has no fundamental rights under the Constitution of India. See, it is an artificial person. A company also has its nationality and domicile. If a company is situated or is created in India, then it has a nationality of an Indian company. So it has the nationality and domicile, but it does not have a citizenship, or does not have a fundamental rights. But it is an artificial person because it is created by the law. Okay. The next comes limited liability. The next point is limited liability. What does the limited liability mean? See, in case of a company limited by shares, see, in limited liability there are 3 types of companies which we will see in the next topic. So, in case of company limited by shares, the liability of shareholders in a company is limited up to the value of shares held by them. Okay. And in case of companies limited by guarantee, the liability of members is limited up to the amount guaranteed by them. Okay. However, in case of companies with unlimited liability of members, liability of the members continues till all the debts have been paid by the company. But this privilege of limited liability is not absolute. Okay? So in this case, there is a limited liability on the members. If you see in limited liability, there are 3 types of companies. Company limited by shares, company limited by guarantee, and unlimited companies. So the companies which are with limited liability, they have to pay the debts according to the value of their shares only. Okay? That is why this is the 4th characteristics, that is limited liability. Next comes perpetual succession. See, once a company is registered as per the provisions of the Companies Act, it continues to exist till it is finally wound up as per the provisions of the Act. Okay. For example, see, after the death of members, the shares are transmitted to their legal representatives who will then assume the membership of the company. In a simple way, perpetual succession means that if a member dies or if he is insolvent, it doesn't mean that company will come to end. A company will come to end, or it will come to liquidation, or it will wound up only in the way through the act, that is through the Companies Act. It can only be brought to the end by the law, that is the Companies Act 2013. The death of the member, the insolvent of member doesn't affect the existence of the company. That is the meaning of perpetual succession here. Next comes transferability of shares. See, section 44 of Companies Act declares that the shares or debentures or any other interest of any member in a company shall be a movable property that can be transferred in the manner provided in the article of the company. Means the shares are considered what? A movable property. It can be transferred from one member to the other. Thus, incorporation of company allows its members to sell their shares in an open market and to get back his investment without any hassle of withdrawing money from the company. It means what? The shareholders can transfer their shares to any other person and can get back their money. That is the meaning of transferability of shares here means. Okay. Now next point is common seal. See, a company not being a natural person cannot sign documents of itself. Therefore, a company would require some other facility to authenticate or approve the documents. Okay. So in this case, the common seal with the name of the company engraved on it is therefore used as a substitute for its signature. So it is required to be kept in the safe custody of a responsible official. In fact, the board of directors are responsible for the safe custody of a common seal, and any document bearing the common seal of the company will be legally binding on the company. So common seal is basically created because a company cannot sign the documents itself. So that is why a common seal is created with the company's name engraved on it. So that is here the common seal means. The next point is separation of ownership and management. In case of sole trader or partnership, the owners manage their business. But in a case of a company, the members are scattered over a vast geographical area and as such cannot actively participate in the day-to-day affairs of the company. So they elect their representatives called board of directors who are responsible for managing the affairs. Okay, so the actual working of the company takes place through the paid employees headed by the chief executive officer. In this way, it is possible for the company to harness best skills and expertise in the concerned area of its specialization. Okay, this helps a company to improve the efficiency of its business transactions. So means here what? Owners are different and the management is done by the others. Who are the owners of the company? Shareholders are the owners of the company. But actually, who are managing the works of the company, the day-to-day affairs of the company? The board of directors. So here what happens? Separation of ownership and management. Owners are different and the people who are managing the day-to-day affairs of the company are other. So that is why there is a separation of ownership and management. Next comes limitation of action. See, a company cannot go beyond the powers stated in its memorandum of association. See, memorandum of association is a principal document which is required to be filed with the registrar of companies. And in that, the powers are stated, the powers of the company are stated. We will discuss the memorandum of association in the third chapter in very detail. So it means what? A company cannot go beyond the power stated in its memorandum of association. The memorandum of association of the company regulates the powers and fixes the objects of the company and provides the edifice upon which the entire structure of the company rests. So the actions and the objects of the company are limited within the scope of its memorandum of association. So whatever the powers which are dignified in the memorandum of association, that only can be exercised by the company. A company cannot work beyond its memorandum of association or the powers which are stated in the memorandum of association. So that is the meaning of limitation of action is here. Okay. Now next comes termination of existence. The next and the last point is termination of existence. See, a company being an artificial judicial person does not die a natural death. It is created by law, carries on its affairs according to law throughout its life and ultimately is effaced by law. Generally, the existence of a company is terminated by means of winding up. However, to avoid winding up, sometimes company adopts strategies like reorganization, reconstructions, and amalgamation. So a company cannot die a natural death. So it can be brought to the termination, or it can brought to be the liquidation purpose only by the law process. Okay. So that is the meaning of termination of existence. Now we will see the distinction between a company and a partnership. What is the difference between a company and a partnership? So let us see it. See, the basis of distinction, company and partnership. The first is here enacted by. In which act it is by which act it is created. So a company has been created under the Companies Act 2013, while the partnership form of business is governed by the Indian Partnership Act 1932. Next basis of distinction is legal entity. See, a company is a separate legal entity from that of its members. That I have told you that a company has a different entity from its members. While if you compare with a partnership form is not a person in the eyes of law. Here it is a separate legal entity. Here the partnership form is not have a separate legal entity. Okay. Next comes number of members. A company must have minimum 2 and maximum of 200 in the case of private company, and minimum 7 and maximum unlimited number of members in case of public company. Okay, but in case of one person company, only one person can be are allowed to form a company. So here are the number which are required to form a company. But in partnership case, what it has been said, partnership firm must have minimum of 2 partners and maximum of 20 partners. So this is the number of members. Now next point of distinction comes personal liability. See, members of a company are not personally liable for its contracts, debts or wrongdoings in case of a company. But in case of a partnership, members are liable for the contracts, debts of the firm. Okay? Next comes ownership. The property of a company belongs to the company and not to its individual members. So whatever the property are, it belongs to the company, not to the individuals in case of company. But the property of a partnership firm is the joint property of the partners. Matlab, whatever the property is there in the partnership firm, it is a joint property of all the partners who have formed the partnership firm. The next point is management. Management of the activities of a company is done by key managerial personnel, which we call key MP, and board of directors. Means the company's management work is done by the key managerial personnel and the board of directors. While in the case of partnership, the management is done by the working partners. Okay. Now next comes transfer of shares. See, shares in the company are freely transferable unless it articles provides otherwise. But in case of partnership firm, the partner cannot transfer his share without the consent of other partners. So he is not allowed to transfer his shares without the consent of other partners. But in case of company, shares can be easily transferred. Now comes the next point, that is powers. Company's powers are limited by its object clause stipulated in the memorandum. Partnership firm has no limits to its activities. Earlier I have told you that the company's powers are limited to its memorandum. Whatever the powers it has been stated in its memorandum of association, only that much a company can exercise, and beyond its limit it cannot exercise its power. Okay. Now let us see the further distinctions. Liability of members. For the repayment of debts, the liability of members of a company is limited, except in case of an unlimited company. Means whenever the company has to repay the debts, the person or the members of the company can only pay its liability to the value of its shares. Okay, but in the case of partnership, the partners have unlimited liability in all the matters relating to partnership firm. Next point is insolvency or winding up. Winding up of a company does not make the members insolvent. Means whenever the company is winding up or whenever the company is liquidated means या winding up मतलब जब कंपनी को बंद करना है या उसको डिसॉल्व करना है, तो उसका मतलब ये नहीं होता कि मेंबर्स इंसॉल्वेंट है. ठीक है. बट द इंसॉल्वेंसी ऑफ पार्टनरशिप इज द इंसॉल्वेंसी ऑफ ऑल पार्टनर्स. बट अगर जब हम लोग वाइंड अप कर रहे हैं, बंद कर रहे हैं एक पार्टनरशिप के फॉर्म को, इसका मतलब ये होता है पार्टनर्स भी इंसॉल्वेंट हो रहे हैं. गेटिंग इट? सो दैट इज द मीनिंग ऑफ इंसॉल्वेंसी एंड वाइंडिंग अप. नेक्स्ट कम्स अकाउंट्स एंड ऑडिट. A company should maintain accounts, and auditing of accounts by certified chartered accountant are compulsory. Whereas in case of partnership firm, a partnership firm has to maintain accounts as per the conditions stated in the partnership deed. Here it is a compulsory and here it is conditional if it has been stated in the partnership deed. If it is not, then it is not mandatory. But in the case of a company, it is mandatory, it is compulsory to get the accounts certified by the chartered accountant. Next point is dissolution. A company has perpetual succession, hence death or insolvency of its members will not affect the existence of a company. The company's existence will come to end only when it is wound up according to the provisions of the Companies Act. As I have earlier told you in the characteristics of a company, that a company has a perpetual succession, means that the death or the insolvency of its members who are managing the company will not affect the existence of the company. A company can only brought to the end, or the existence of a company can only brought to the end according to the provisions of the Companies Act. Okay, but if you see in the case of partnership, it is a partnership firm does not have a fixed period and partners can dissolve it any time, or it can be dissolved automatically by the death or insolvency of a partner. So in case of partnership, the death or the insolvency of partner matters the partnership firm. It can make the partnership firm dissolve. So this is the difference between, in case of dissolution, between a company and a partnership firm. So these were the distinction between a company and a partnership firm. So in this lecture, we have covered the meaning and the definition of company, nature of a company, characteristics, and the distinction between a company and a partnership. I hope you all have understand till now, and we will meet in the next lecture with a new topic. Thank you.